Hello, everyone, and welcome to today's webcast, Operationalizing CCPA, the People, Processes, and Technology. Before we get started, a few housekeeping notes. All of your lines have been muted to reduce background noise, but please feel free to shoot the panelists questions throughout the presentation using the questions feature that should be on the bottom right-hand side of all of your screens. Today's presentation will be recorded, so if you have to step away from your desk, don't worry. We'll send out the full recording after the conclusion of today's live broadcast. I see quite a few folks are still joining, but we do want to be mindful of everyone's time. We know you've set aside a full hour for us, and we very much appreciate that. So let's get started. We've got a great roster of experts today for this discussion, and our moderator will be Lee Holcomb. Lee?
Thanks, Sarah. Thanks, everybody, for joining us today for our discussion around how to operationalize the California Consumer Protection Act. My name is Lee Holcomb, and I'm the Director of Operations for the Enterprise Legal Solutions at Logility. I'm an attorney, and I have my CIP US certification. Prior to joining Logility, I was a partner at Leitner Williams Dooley and Napolitan in Tennessee. And then in 2006, I took a stint overseas with the US State Department, and that's where I started working with the legal services industry. Before we get started with our conversation, I would also like to introduce our esteemed panel. We have Gretchen Ferris. She's the Director of Business Development at Logility. Gretchen, you want to tell the audience a little bit about yourself and your role with Logility?
Sure, thanks, Lee. As Lee mentioned, I'm a Director of Business Development, and I'm located in Bentonville, Arkansas, which is in the northwest corner of beautiful Arkansas. I have a legal research and abstracting as a judicial law clerk background, as well as a boutique commercial litigation firm where we specialize in plaintiff construction work. And then lastly, I've got a few years of corporate compliance and ethics experience, which brings me to this panel.
Thanks, Gretchen. Chad Riley is also an attorney and our solutions consultant on the panel today. Chad, can you give a little bit about your background? Chad, you might be on mute.
My apologies. So I'm originally from Houston, but based in Chicago. And like Gretchen, I am an attorney, and I practiced for about 5 years in the commercial litigation space. And I've been on the vendor side for about 6 years now. And I'm a solutions consultant with Logility and help clients manage their data-related needs.
Super. And next we have Eric Stansel. He's a senior project manager with Logility. Eric, some of your background, please.
Sure. I'm also an attorney here at Logility. Been with Logility for, I guess, 11 years now. I have an MBA in finance, and so I'm able to use that sometimes when some of our work. A lot of my work concentrates a lot on technology history review and also kind of new matters like the CCPA, helping to deal with some fairly unique workflows, developing new workflows. So that's a lot of what I concentrate on. I used to be an insurance regulator for a while, worked in some political consulting as well. So hopefully some of that's kind of CCPA related as well.
Great, thanks, Eric. And Jonathan, last but not least, tell us about your background with Logility.
Yeah, hey everyone. I'm based in the Atlanta office for Logility. Works basically kind of runs for our Southeastern group. And you know, I've been with Logility for 10 years in various positions. I've been a senior solutions architect for about half that time, I would say, with Logility. Previous to being with this company, I was a chemical engineer and computer engineer for Honeywell. And then I was a litigator for over the last 15 years, and I'm still a practicing attorney on the side, but I primarily do solutions design for the legal world, you know, with Logility.
Thanks, Jonathan. So on the agenda today is the California Consumer Protection Act. And as we all know, privacy has become a huge issue for all companies, and the CCPA has kind of been one of the leading movements in the US on this issue. At Logility, we've seen many companies reach out to our teams for a variety of problems around privacy, and in particular, the CCPA. So today, we thought we wanted to have a discussion around some of the issues we're seeing and some of the solutions that our experts are putting together for how to kind of operationalize the CCPA. And what we mean by that is, if you think about it, the CCPA at its core is not that complex. The provisions aren't. But if you put it all together and you try to implement it across an organization, all of a sudden it becomes this huge monster, and it becomes quite complex and difficult at times to put in place and make work for your organization. So what we want to talk about is kind of how to break down some of these processes and put them in place. So how to minimize exposure to data breach class actions under the CCPA, for example, or how to architect and implement a system where you put in place your data subject access requests or your DSARs and how to deal with those, or how to develop and track negotiations around data privacy and security specific client contracts. So we just want to kind of table a discussion. This is meant to be an open platform where would love to hear your questions, hear some of your challenges, field some of your comments, some of your successes and failures that you've had so far. So please don't hesitate to use the chat feature. We'll try to interject those real time, but if we don't get to them in the present moment, we'll try to catch them at the end during Q&A. And we thought, just to get the ball started, we'd have Gretchen give a little overview of the CCPA, where it stands today, and some of the areas that are changing. Gretchen?
Sure, thanks, Lee. Yeah, let's just get a quick background so that we're all starting from the same point. So this is a bit of a gross simplification, but to know if your organization is subject to the CCPA, there's a three-prong test. And if you answer yes to either one of these prongs, you're subject to the CCPA and have to comply. The first is, do you do business in California and have over 25 million in annual revenue? Or do you hold more than 50,000 California user data? Or do you earn more than 50% of your revenue from selling of California user data? So if you answered yes to any of that, then your business is subject to CCPA. This does not include healthcare providers or insurers who fall under HIPAA. This does not include financial companies who fall under the Graham-Leach-Bliley Act. And finally, this does not include credit reporting agencies who are subject to the Fair Credit Reporting Act. Those are some carve-outs for those specific industries. But one thing that I'm sure you all know, and that if not, you'll learn quickly, is that the CCPA is constantly evolving, constantly changing. So, be on the lookout in case you think, okay, I'm not subject to CCPA because I fall under one of those exceptions, because it does change constantly. So next, let's talk about what data is covered. Presently, only consumer data is covered under the CCPA. However, there are notice requirements for other categories of data, such as employee, job applicant, contractor, business-to-business data. You do have to give notice at the point of collection when you're going to collect any of those categories of data from them. And just as an aside, when it comes to employee data collected at the point, when it comes to employee data collected under the GDPR, which a lot of people will compare the GDPR to the CCPA, even though, in my opinion, they're pretty wildly different. You'll see that it's largely unstructured data versus the predominantly structured data, which consumer data comes in as. And one of the more technical colleagues, Eric, Jonathan, or Chad, will touch on that subject a little bit more, the difference between the unstructured and structured data. So jumping back to the consumer data, a consumer's personal information is broadly defined under the CCPA to include any data that identifies, relates to, describes, or could reasonably be linked directly or indirectly to a particular consumer or household. This is obviously a sweeping definition, and we strive to help our clients err on the side of overcompliance in an effort to honor not only the letter of the law, but the spirit of the law. And one caveat on that is that any data that is contained in a publicly available government record is exempt from this consumer data category. So that's an idea of kind of what consumer data is covered. And it's, like I said, it's broad, sweeping, anything that can identify the person or create a customer preference profile. Let's move forward to compliance. So you're subject to the CCPA. You know what data is covered currently in 2020. What do you have to do as a business? Well, you have to create procedures to respond and to requests from consumers regarding their data who are asking you to either opt out of sale and disclosure of their information, and or they can ask you to delete their data and or ask you to disclose what data you have on them. These 3 requests you'll hear referred to as DSARs, which Lee referred to previously. Let's see. Under the requirements for how consumers can request their data from you, their opt-out or their delete rights, you have to have 2 methods as a business. You have to have 2 methods for receiving these requests. And one of these methods has to be a toll-free number. The other one can be email. It can be, I know that some companies are doing in-store. If they have a brick and mortar store, they're doing in-store requests. So there's a number of other ways that you can get that second method. Businesses have 45 days to comply with the CCPA requests, but you can get an extension for 45 days beyond that first one. Any non-compliance can bring about pretty heavy penalties, so you want to watch out for any areas that are kind of slipping under your radar. The California AG can bring civil injunctions. They can bring $2,500 fines for violation, or in the case of an intentional violation, they can bring a $7,500 fine. Beyond that, where your business was shown to have a failure of safeguards and a consumer data was stolen or disclosed, the consumer can actually have a private right of action against your business in addition to the AG penalties. So it can bring a pretty hefty fine with it. Obviously, California has led the way in privacy laws, but other states have and will continue to follow. And before we know it, the privacy laws will just be prolific throughout the states. And I'm sure that we'll see a federal mandate eventually on that. Lee?
Yeah, thanks, Gretchen. That's a good overview. I think all of us appreciate that. And then Eric, if you want to break it down a little further and maybe give an example about some of the work that you've done with a large retailer or another client on how to get DSAR requests in place, that would be great.
Yeah, sure. Thank you, Lee. So what I'm going to talk about a little bit here is what most of you are probably going to think about when you think about having to comply with CCPA. Now, we're going to talk about a couple of other things in a moment as well, but what you're probably going to think about is structured data. And by structured data, all I'm talking about simply is that data that's being held in a database or something to that effect. And I think John's going to go over a little bit more unstructured data, which is what you're going to think about with email and that kind of thing. But what I'm going to focus on is structured data. And it's very important because the client that we'll kind of use some, I won't say examples of, but that will color part of this has a lot of structured data, a lot of databases, that kind of thing. So understanding that structured data is very important in order to comply with CCPA if it very directly affects you. So let me step into just a few of the steps that we talk about here. One is the request being made, and as Gretchen pointed out exactly correctly, there are a number of avenues that can come in which that data can come in, the request can be made. What we mainly have dealt with is website data. In other words, they have a form and put it in, kind of their identity and what they want. And the reason that is kind of applicable here and maybe important here is when you're dealing with structured data, and especially when you're getting a lot of requests, having that website and that form is incredibly important. It's great to get the physical mail, fine, getting the call in, all those kind of things just add one layer of human error potential, all those kind of things. So I would say it's just kind of a best practice. If you can steer people to a website and putting it into a form, I would highly recommend it. It's going to make your life a lot easier, tracking those things down a lot better. There's some funny things that I've read in the CCPA itself. With, it has where you can have email submissions if you're online only. But if you have a website, then you can have website submissions. And I'm frankly trying to figure out how you could have an online presence and not have a website. But that's a whole nother thing. So let me know if any of y'all have that experience and can tell me what the difference is. I couldn't figure it out. But that request being made is obviously the very first step, and that's a consumer-oriented request that they make that first step. I would say with that request that something maybe some of you may not be aware of, at least my understanding is that if you have subunits, if you have different sections within your company, I mean, by that I mean different business units that maybe you acquired a unit or something like that, and you're doing business in California, say there's 2 of them, consumers going to have to submit a request for each one of those business units. At least that's one interpretation that one of our clients has seen fit to follow that rule. But please be aware that there are some questions there, and that there are different ways to handle that request being made. But that brings us to the second spot. So the request is made, and then you're going to have to confirm the requester's identity, whether that's a system login where they have, I guess a profile with you, credit bureau confirmation, which we can talk about, or if it's in store, obviously government issued identification would be fine. The reason that part is really important is because I think most of you, that deal with a lot of customers are aware of this, but there's a shocking amount of the same names and people in the same cities even. So getting that information down pat is very important. If you fail to do it correctly, if you send Eric Stansel's information, but it's not this Eric Stansel, someone else's, and then you could have a data breach. You could have a problem on your hands. So with the clients that we're working with, they're very cognizant about that. And an example that I'll give you, for instance, is the credit bureau check. So those questions that you get asked when you say, when you're trying to get your credit report, whatever, where it says something to the effect of, well, how much was your last mortgage, or before this one? All those things that I can never remember, but some of you may have written down detailed notes about. We have to, they have to jump through that hurdle, and it's not a bad hurdle at all. And I will tell you that there are a lot of fail points there when customers end up not, going to that next step. So it is a very important thing, and it does weed out a lot of problematic issues there. So if you don't want to have a data breach, that's a good first defense. The next thing is, when you've got the request, you've confirmed the person's identity, you have to determine where the location of all this information is. And for some of you with larger businesses, with tons of different databases, it's an issue. It's a lot of work. And so there's a lot of data mapping to be done, identification of sources, figuring out where that data is, how it's being held in the various databases. And I'm not a tech guy, but I can tell you that it is a big planning piece. And then there's another piece that kind of ties in with that, is not just identifying the sources. And again, it's going to be the sources of anything where you're holding your customer's data over the last 12 months, I believe, and mapping it. But then you need to think about the connections, because knowing it's in these far-flung 10 or 12, 15 databases or whatever. If you're keeping credit card data here in a hyper secure environment, shipping data here, website, access data here, you got to find a way to consolidate that. So those connections from these different databases into a centralized spot, whether that's behind your firewall, whether it's with a third-party vendor, whatever it is, those connections and getting that data over in frankly a readable manner by humans is very important. And we'll get to why that is important in a moment. But there's a lot more to it, from my understanding at least, having not had to deal with it myself. But there's a lot to it, and making sure that data is carried over properly. And those determinations need to be made very, very early in your planning process for, getting your CCA compliance working properly. The next big thing is, the review and processing of the information. There's a workflow that has to be followed, and the workflow issue is more important than you might think. It's workflow discussions are boring. They're boring to me, and I deal with it every day. But determining how that workflow works is going to be big, because you have to be defensible, essentially. You want to make sure that you're actually doing what you say you're doing, you're documenting it, and the workflow, putting it out there for all of us is incredibly vital, because without it, it's kind of like just having, it's basically having a playbook. And if you don't have it, you're going to have a real problem. And I'm going to speak through the rest of this because I want to get into some specific elements in a minute. But I would also note the protocols for deletion and disclosure need to be both developed and followed, and they are going to be different. The deletion protocol is a little different than the disclosure protocol. If it's disclosed, you have to know what's going out, what has to be masked, and what has to be redacted. Disclosure is kind of the place where there's the most chance for real danger. And I can tell you that, deletion, you just have to make sure you deleted it and got it right. If it's disclosure, you don't want a data breach. I just kind of put three things together there. I would say the 3 C's, and again, that's just, I'm not going to, copyright it, so you can steal it if you want. But confirmed, you got to identify the right person, identify what's going on. Complete, you have to make sure that the information requested is complete. That you essentially have all that information there. There's nothing lacking, and there's not too much there. And then it's correct. Frankly, the disclosure follows your protocol, follows that workflow. It does exactly what you're supposed to do. And the next step is obviously delivering that information, whether it's information prepared and processed. How do you do that? How, you've got it all in some centralized location that you're going to get it ready for your customer or consumer. You've got it all there. Are you sending it out via email? Are you sending it out via US Post? How are you getting it out to your folks? Is it different avenues for different people? Understanding that and getting that right is very important. So the delivery of information, none of all the rest of it's for naught if you don't get that right. Lee, if you could advance to the next slide for me.
Well, Eric, before we go on, you have actually inspired a question that came in.
Okay.
It says, if my business does not store government issued ID numbers, can they still use that as a verification of identity? Open friend, name and address on the ID match my file.
Yeah, I mean, it really is just identification, same as you'd be in any store. That it wouldn't have to be stored per se. It would just have to be assuming again that the government issued ID is a valid ID.
Great, thanks,
if
Eric.
That answers the question. I hope it does. So this slide was from Jonathan, and he was very helpful in kind of getting this. But I think what's important here is I want to show you this slide, and John, jump in, or anybody jump in, but this slide is designed for EDiscovery. And the reason I wanted to especially mention that piece is a lot of what we're talking about here with the structured data part, and John may agree on this as well, with the unstructured data part, is incredibly similar to EDiscovery. Now, there are very important deviations from it. I want to stress that. But if you look at it, when we talk about identify and preserve, that's kind of that, the customer says, hey, this is who I am, tell me what you have on me. Collect and process, again, and search, that's all going to be, hey, what are these data sources? How do we get those into a centralized location? Search is going to be that same kind of piece, kind of tying with managed review of, hey, let's look at this. Let's look at the data to make sure that it is properly masked. If we're disclosing it, again, just when we're talking about deletions, it's just making sure that everything's deleted and then kind of auditing it. But if you're talking about a disclosure, we need to kind of have some eyes on that, at least for a while, as we've seen with some of our clients. You have to make sure that what you think is there and what you think is masked is actually masked, and what you don't know is in there can be a problem. We have HIPAA stuff that's in there sometimes, so we have to make sure that that's kind of goes to that managed review. And again, produce is the same thing as kind of mailing it out as well.
And Eric, I was gonna kind of say, one of the big things here, right, is that it's the idea here is behind privacy and removing, folks are asking, hey, delete my data, give me a copy of my data. So you run into this catch-22 where you've got to start copying data over and over again that you're responsible for deleting or protecting. So the CCPA, while it's a compliance effort, it's not litigation. So we talk about EDiscovery and these kind of pieces to it. So it's truly a different legal context here until you get to my section, and I'll talk about why people look at unstructured data. But the same principles are at place. You have to have a defensible process so you can say that you've complied, but you have to take care of what you're doing, because you're going to start creating all these copies of things that you're actually responsible for complying to delete. So it's a lot of the processes that have worked for EDiscovery, which requires, that you meet these legal principles of preservation and chain of custody and all those kind of things, really apply here for a different purpose. But in reality, the tools work very much the same way and should be used very much the same way.
That's exactly right. That's exactly right. But John mentions a really important element there is being very careful about not getting into that circular thing where, okay, well, I'm preserving this, I'm sending this over to this third party, in our case, relativity, spoiler alerts, we use relativity to centralize that data. But when you have that copy over here and they've asked for a deletion, for instance, well, do you want it to get over there? Probably not. You might want to delete that behind the firewall. But for disclosure, you may want to push it over to that third-party relativity and then get rid of it later. So I think that's a good point. Lee, would you, next slide, please? Okay, now I won't go too deep into this. And again, John was the architect of putting this together, and thank you, John. But I think the phases that we follow are very much online here. So if you look at the top here where it talks about initiation phase, review phase, and production phase, again, this is very much kind of in the same vein as what we call traditional EDiscovery. And that initiation phase is just going to be where we have a DSAR request. And do we gather that information? How do we gather that information? When does it get to the point of gathering it, identifying all those kind of things? And then when we get everything together, kind of move to that next review phase. We push it over into the initial review of data. And in this case, again, I will stress that we're discussing that disclosure stuff, where we're disclosing to the customer, to the consumer, what data we're holding on them, what kind of we're keeping up with.
Hey, Eric,
yes.
As you're walking through this, you've had another question come in.
Sure.
The audience is just wanting a little bit more definition around what we're talking about when we say structured versus unstructured data.
Sure.
If you could just go a little bit more granular for that, I think it would help the audience.
Yeah, structured data versus unstructured. So, and again, Chad and John are probably going to correct me on some of this, and that's okay. So, structured data is that data that comes in that you're kind of keeping in the course of business. Again, I think it's commonly, say you go to a website to buy something and you say, yeah, you can keep my shipping information. You can keep my credit card data so I can more quickly get through. What websites, what did I click on when I came to your website? Cookie information, that kind of thing. If you have things like, it's not really structured data, but let's call it structured data for now. If you call into a call center and they keep notes on that communication, any of those kind of things, that's kind of where I'd consider structured data. And again, call center notes, that might not be considered that, but
yeah, and maybe I can help a little. Email is unstructured, right? Word documents, PowerPoints, typically Excel's, the documents that most of us are used to as a document, right? Whether they're electronic or they're printed out in paper, they're unstructured data. It's usually some sort of narrative or something like that you can work with and use. Structured data, on the other hand, is essentially a database, that you have, you type your name into a form on a website, and that's going to put it in a database somewhere, right? Somebody's going to have large tables of information that's categorized up with your name and your address and your social security number, whatever. That would be structured data. And there's different ways data can be structured that is technically not a database, but that's usually it. So if you're a company that has a lot of database, especially with customer information or maybe employee information, an HR database, for instance, that has contacts in it, that kind of stuff, that would be structured. And virtually everything else that you have in your business, would be kind of unstructured, just the typical documents and things, that an office would use.
Yeah, if you want a simple answer, then sure, that's fine, John. So you want a simple answer.
I think that's really helpful.
So, he got it right. All right. So yeah. So the biggest thing is when we start this review phase is just understanding that for the CCPA purposes, we're talking about disclosure. We're not talking about, deletion. Again, deletion is just kind of a slightly separate animal, and bluntly, it's a lot easier as long as you audit to make sure you're right. But the two pieces that I would note is when you look at that data that you've got coming in and that's going to be going out for, for disclosure purposes, there's basically two things you want to do. Is there stuff you can mask? And when I say mask, what I'm talking about is there an automated process you can cover, say all but the last four of social security numbers, or all but the last four digits of a bank account or a credit card number, anything along those lines. Anything that you can, in an automated sense from that database, hide via asterisks, via dashes, whatever. There's also the concept of redactions, and redactions are going to be, at least in our case, what we're going to be covering on that is something that is not easily, there's not a pattern per se. It's not regular expressions in many cases, or it may be somewhere in a database that they didn't think to use that. HIPAA stuff is going to come up a lot in that instance. Maybe something where a credit card should not have been, but maybe it was kept by, a call center notes or something weird. That's where you'd want to be looking at, having an opportunity to do some redactions. So that way, when you send something out, you're not sending out anything that's going to cause a data breach in some manner. So I would stress that that's very important as well. And getting those things right takes a lot. It takes a lot. And we'll mention that in a second, but it does take a lot of effort. And then obviously you're going to be some review that's going to go on to make sure that whoever did that first pass, look at the documents, is going to confirm it. That's our second level review. And then we get in the production phase, which is simply imaging that in general. It's generally going to be PDF'd or TIFF'd or something along those lines, probably PDF'd, to send out to send out, whether that's via electronic mail. Hopefully you can do that, it's a lot cheaper. Or it may be where you have to send out some stuff via the US mail service. And I think we can go to the next slide. And this is where my good friend John is my hero, because all the stuff I've been talking about is great, very important. I can tell you, if you don't have the ability to track it, it's going to be a real pain for you. And John can do wonders with some databases on setting some things up for us. But before I turn it fully over to him, I'll tell you two things. One, we have to be able to track it, and that's just very important to make sure nothing falls through the cracks. The other thing is, if you're in someone like my position, where we've got teams of attorneys that are looking at this data, if you don't track it like this, it's hard to manage. It's incredibly hard to manage. And I don't mean just from making sure things don't fall through the cracks, but I also mean from process improvement. It's hard to improve the process and better things if you're not tracking, if you're not keeping metrics. So let me tell you that what John has set up for us has been, again, I keep saying, but it's been invaluable. And so, John, there's a lot of weight there on you. Show them how it's done.
Right. So yeah, the big issue we had when it came to us was scale. We knew that, I think a lot of folks, when CCPA was coming, everybody thought, okay, it's going to be a law like GDPR. It's been in place. GDPR was expensive, and it's a big, difficult compliance aspect of it. But the DSAR work didn't turn into a massive undertaking for most companies. Those responses where a customer or someone says, hey, I want to see a copy of my info, or I want you to go through and delete everything. They just hadn't seen a massive amount of that. We'll talk about what, I'll make some distinctions about what is really going on with GDPR versus CCPA. But what we had was, in California, they released it and said, hey, customer data starting January 1st, 2020 is now subject to this. And it was a massive initial surge of these requests. Hey, I want to see what you're keeping on me. What do you have? And that's where you begin to scramble. So if you start looking at the issue of hundreds, if not thousands of these requests, and they're all on 45 to 90 day kind of turnarounds, you're going to be looking at, a lot of just simple tracking. Where am I? What am I? If I got this, am I prioritization? As Eric said, we put a team together that actually answers these, and builds these responses, reviews the documents, and masks the data, QCs. I guess electronic efforts to do that data masking and sifting through to ensure that what you're turning over is the right stuff. So to coordinate that team of, how many people was it, Eric? 30 folks initially?
Yeah, we got 20 right now.
Yeah. And so, that's a pretty big coordination effort. So that's what we did. We set up a whole process of intake. When they initiate, they send an email or they do a request in some way, and then we log it into the tracking system, which is like a ticket keeping system if you're into IT or some of those kind of things. And then with that, not only did we track through the workflow, but we wanted to make sure we tracked proper KPIs to really ensure that we're handling the data efficiently and effectively through the process, that our client isn't overpaying, right? That we start to figure out benchmarks on what this stuff costs, and as we make improvements to the system, being able to track what the effect those improvements have, whether they're improvements or not, right? We can make, oh, this will speed us up, and we look at it, nope, that was more complicated. So we track the amount of time spent preparing these responses, the amount of cost, in addition to the calendar prioritization of getting it turned around in time. And using that, we looked at all kinds of things, and you can, our underlying metric, and this is one thing I did want to touch on. I think our underlying metric is page count, versus many other things you could use. In the EDiscovery world, a big metric is document, and net or gigabytes, or some of these kind of easier objective things to get that you can get before you process the data into images that need to be delivered. But when you're in the masking world or redaction world, I guess, pages really becomes a bigger element to that, because you've got to look through every page and ensure that it's done appropriately, and or apply a redaction or do those kind of things. So we started tracking on that to be able to kind of get our baseline metrics, and to see how we're doing. And then over time, we kind of measure to look to see, are we getting more efficient? Are we able to bring different technologies and processes online? And what are the effects of those things? And the virtue of putting it into a system like this is we set up reporting that goes out to the client on a routine basis, measuring those effects, and then come back and revisit, where we are. Okay. All right. Well, any more on structured data, as we say, or database work? We can, we'll pivot over then. So this is, please ask questions, and panelists, feel free to interrupt me. This is my portion, I guess, to kind of go through and kind of break things down with unstructured data, which is what most of us think of as my corporate records. For most companies that aren't dealing with large customer databases, this is what you're going to be concerned with GDPR eventually. And the interesting thing about this is, not GDPR, CCPA. The interesting thing about this is the CCPA provisions that we're really going to start impacting this don't go into effect until January 1st, 2021. So to kind of step back and look at it, as we said, unstructured data is documents. Where I think this is going to have the biggest role is with employees for large companies, right? We have the cutoff of 25 million a year going forward. So if you're small, as Eric, you were talking about, oh, I'm a small company, it might not have a website, that kind of thing. Maybe I have an eBay storefront or a Facebook storefront or something like that. You're going to be probably under the limit for CCPA unless you're trading in consumer data, and you're probably not, right? You're just selling items. But once you get to be big enough, right, above that response, you're suddenly within the world. Whether you traffic or trade consumer data, you're still, you're going to have employees, you're going to have all those kind of things. So we believe that what's really happening is we're looking at the future of what's happening with GDPR. And GDPR has really come out and been an employee or former employee effort. So over in Europe and Britain, which I guess is kind of part of Europe now, I'm always confused by Brexit and all those kind of things, but GDPR applies to all of that. What they're finding is when, former employees or employees that have have some sort of potential employment claim are using GDPR to get copies of their employment file, to get information about their situation. It's kind of a sneak peek to filing either some sort of government claim or investigative type work. Here in the US, it would be a EEOC type claim, or some sort of wrongful termination or discrimination type lawsuit in the workplace. That very much could be where this kind of goes in January when it comes online for employees. But when I say employees, it's also I'm using it kind of as a short compression of several folks. It's not just employees, but it can be employees, it can be applicants, so people that apply for jobs with your company, independent contractors, the emergency contacts and data that you keep on folks, so independents. So it runs the gambit of a lot of different folks that may be associated with that employee, or may, as an individual, engage with your business in a business method, that are employee-like. And they don't even have to be hired, right? It could be somebody who comes in, does an interview, and you have their resume in a database somewhere, or you have your resume on file, or you've emailed back and forth with them to get that data. All that can come into play when you're looking at dealing with unstructured data, right? So there's the deletion aspect, as if someone says, hey, yeah, I may have applied for a job with you guys, but I want that gone. Or a former employee, is left and said, hey, I want, for instance, I've gone on, I've had a lot of health issues. I brought all that up, and then I get laid off, right? So now I want all that information. I want to know what's been going on. So that's where we kind of see it going. That's where GDPR has gone. And it will be interesting. There are limitations, and I did want to get in a little bit and kind of distinguish between CCPA and GDPR, because I'm living in the predictive world here. And in fact, I talked to my panelists, I think ahead of time as we were preparing for all this, is that a lot of terms in the CCPA are very vague. This was not trying to be political, but the idea is it was a very rushed, from a process standpoint, it was a very rushed bill. It was put through by the legislation in California very quickly in order to actually keep it from being a ballot initiative. And there was strong procedural reasons for that. They wanted to make sure, because if the law passes a ballot initiative, it'd be very difficult to update it and modify it in the future. So if the legislature passed it and put it in place, then they had a lot more freedom to work with it and amend it as they wanted going forward. And to some extent, because the unstructured or the employment stuff isn't going to happen until 2021, this stuff could change, and there could be more as they work out the kinks. That's part of the reason there's a phased approach. As they work out the kinks with what's there could be some adjustments and things. So if I get something wrong, it's probably because it changed since I last looked at it, or I will be right when it eventually gets there. Is my
Great.
Yeah.
Thanks, Jonathan.
Yeah.
Are we ready to move to the next slide and hand it over to Chad now?
Well, no, I wanted to go through just a couple more pieces to kind of look at it. A couple little things you may want to caveat and be concerned with is that, the CCPA only deals with, I think, 12 months. So you go back, GDPR deals with a lot larger area. So when you're looking at this kind of stuff, folks are coming in and, asking for all this data, so you're going to be probably served with a request for an employee that's going to have a lot more detail in it. It's not just going to be some guy saying, hey, I want my stuff. They're going to come in and ask probably for some particularized information. And you may have a lot of HIPAA type information where they discuss their health situation. You may have a lot of other things that go into this data, and you've got to collect it all and present it to them. There's a big issue, at least in GDPR, where it's not as cut and dry as I would have thought it was once we started getting into it. But you have a strong duty to protect the PI of other folks within the disclosure. So that's what you're really doing. One, you're isolating whether what you've collected really is applicable to this subject or the person asking for the data. But then you're going to be spending a lot of your money and time making sure that stuff dealing with other employees is not getting disclosed in this. Now, it's fairly easy with an HR file. It may not be that easy if there was an HR issue with this person that went to email and you're going back and forth. Also, if you're understanding that it's a prelude to a potential lawsuit or an EEOC claim, your duties to disclose under DSAR is not as extreme as it would be to disclose under EDiscovery rules. Where that really matters is you don't have to give them as much information. When you're dealing with an evidentiary standard or a discovery standard, you have to present the full business record over to the person, right? So that means if we talked about them in an email, right, I'm going to have to provide that full email, likely unredacted unless there's privileged or other confidential information that I can properly protect, within that. But for CCPA, and this is what we're seeing with GDPR, and it's not that you're playing games with it, it's just you have a duty to protect. You can protect this information. You're only required to disclose the information that is about them to them. So what we have seen in a lot of cases is if there's a discussion that this person doesn't have visualization into, say it's managers and HR talking about their employment status, maybe part of their health, you can actually mask those IDs, those email addresses, those communicants. So you can provide them the substance of the conversation, but you don't have to provide them who was talking to who was saying what. You can mask all of that. And that's become very commonplace in GDPR. It'll be interesting to see whether that happens in CCPA. But those are just a couple things you can consider, especially if you're looking at potential high stakes situations and long extended discovery costs later, for an employment claim. Oh, yeah. So that about wraps it up.
Yeah, and everything John and I have talked about is great, but I can tell you that none of it really matters except for Chad. So Chad's job is incredibly important. What he's going to talk about is a lot of this data mapping and what we talked about earlier. The technology is the big fail here. If you don't get that right, nothing that John and I said matters. So again, Chad.
Yeah, absolutely. I'd 100% agree with that. So the first step in responding to a CCPA request is long before you have a CCPA request. It's having your data house in order, which means a sound information governance process, knowing where your data resides, how it lives, how it's disposed of. And that really starts with the data mapping process. And that process kind of takes place in sort of two phases. So you have interviews, you're going to go speak with your department heads, you're going to speak with IT, and make sure you hit both of those groups, because what the vision they have for the company and what the company and the business lines are actually doing may differ. So you want to have both of those viewpoints. And then from there, you're going to put together some questionnaires you're going to send out to the key individuals and stakeholders within these departments, and to discern things like the data sources, the types of PII that's being collected, and how is that PII being used? Is it being used to generate ads or for marketing, etc.? And then once you have all that information, then you're going to put together some data lifecycle inventories and visualizations. So that's really trying to get to the heart of where does this data originate, and how is it being used, and how does it flow through its life cycle? Does its life cycle actually end? Are you storing it indefinitely, purging it, archiving it, that sort of thing? And so this process will help uncover things like secondary and tertiary systems. You may be using an analytics tool that plugs into a database, so it may be sort of pulling some PII out that way, and this data mapping process will help you sort of identify that. And for a lot of organizations, especially ones that aren't incredibly mature and don't have sort of complex data repositories, that data mapping process may be enough. For other organizations, you may want to go and do what's called data indexing. So you use certain tools to classify your data. They crawl your networks and your servers and all your data stores, and they'll classify that data for you. And that really takes place in two different levels. The first being data classification or metadata indexing. And that's essentially when you have a tool that comes in and it indexes all your data sources. It builds a metadata index, petabytes of data, in usually just a couple of days. They're very powerful. And that'll tell you things like the custodian, the date the data was created, the age, how much, file types. And you can use that information to then enforce your records management policies, your legal hold policies, get rid of what's called rot data, so redundant, obsolete, or trivial data. And then periodically you'll want to do incremental indexes, where you come in and you just sort of index the delta, any new or changed data. But if you're responding to a CCPA request where you're dealing with PII, you're going to need to take a deeper dive. So you're going to need to do what's called a full content indexing, because metadata indexing isn't going to look inside the text of the documents. It's not going to open container files like PSTs and see the actual emails. You're going to have to dive deeper into the data. So a full content index is a heavier touch. It requires additional permissions. It's going to take longer, but that's where you can use things like pattern matching and regular expression searching. You're looking for PII patterns in your data, like social security numbers. You can use search terms and set these parameters fairly broad so you can segregate pools of data for review into your review platform, which we'll get to in a bit. But one thing I wanted to stress is that technology is not a catch-all. There is no magic button that you can press and the CCPA information governance process is taken care of for you. You're always going to need that human element, and what I believe is the most important element. So an example of that is tools that will go out and do regular expression searches. There may be some PII they miss. So for example, if you have handwritten forms and your customers are filling out forms with sloppy handwriting and those get PDF'd into your system, there's not going to be any extractable text there. And even if you OCR it, you may not get great results. And then those regular expression searches are not going to pick up that data. So always something to kind of keep in mind. So when we move over to some examples of tools that are used for this process, for indexing and information governance, there's a lot of different tools. We at Logility have our own proprietary tool that does metadata indexing. It's a very sort of light touch and easily deployable tool. We also use index engines, which is incredibly powerful and does the metadata indexing and full content indexing. But there's plenty of them out there. There's Stored IQ, Varonis, and just to name a few of these information governance platforms. And you're either going to purchase the software, bring it in-house, maintain the infrastructure, the updates, the security patches, and so forth, or you'll hire a vendor like us to come in and do that for you. And we would install that in the mobile surfer, come in, plug it in behind your firewall, and then run the indexing process from there. There's also some newer sort of privacy-specific platforms. So that's your Athena, DataGuys, OneTrust. They can either be on premises or in the cloud. And these are designed to be sort of end-to-end CCPA-related tools. So they help you sort of map your data, track requests, verify requests, and then respond to CCPA requests. So they're likely not just new platforms that were created for the CCPA. It's likely existing technology and software that some of these companies have sort of maybe repurposed and just maybe added a ticketing system on top of for CCPA needs. But there's quite a few out there with the advent of the CCPA. But once you kind of have your data, we've talked about the data mapping process and information governance, you're going to want to get it into specific document review platforms, whether you're exporting a load file from index engines or you're having your IT team just go and collect pools of data and send it over, or if you're having a forensic specialist come in and image network drives and so forth. You're going to want to get that into a more traditional EDiscovery platform. So that's your Relativity, Everlog, Catalyst, and then some sort of platforms that supplement those review platforms like a BrainSpace. So within these platforms, you'll be able to do some really advanced searching, deploy some analytics to help you sort of triage your review, like clustering or conceptual searching. You also have access to regular expression searches to act as a QC measure to your human review. And then tools like BrainSpace can act as a supplement to perform some more AI-related tasks, sort of data visualizations, communication mapping, entity extraction, where it sort of identifies entities, names, people, places, things, and it groups phrases and documents within those entities. And that's really the technology you're going to use for your CCPA review and responding and producing and redacting documents pursuant to a CCPA request. The last thing I want to touch on just before we wrap up the tech piece is sort of a couple other considerations. So identifying a request is incredibly important, because if you don't identify a request properly and turn that data over, that's a data breach. So there are some tools out there that are designed specifically for this. Most of them are tools created by financial institutions because they already are sort of built to kind of handle this piece. Experience identity verification is one. And then the last piece, and we've touched on it with Logility's DSAR manager, is actually being able to manage these requests. You have a finite period of time in which to respond, and you're going to get deluges of requests that come in at different times. So you need to be able to keep track of that. And an Excel sheet is not a great way to do that. So in addition to the Logility DSAR manager, we have a proprietary business intelligence platform that's called Spotlight that helps you sort of report on and track various metrics and trends in your data, and also works quite well for CCPA requests. But there's others out there. There's Tableau, Power BI, just to name a few. And your organization may already have a business intelligence platform that you can go and kind of get access to and repurpose for your CCPA related needs. So that about wraps it up from a technology standpoint.
Great, thanks, Chad. We did have a question come in, and the audience wants to know, will the right to delete data affect EDiscovery by eliminating relevant information?
I'll take a first shot at that.
Okay.
Let's say the answer is no. Under the CCPA, if there is a business reason to retain the data, you must do it. But also, if there's a legal obligation, you still maintain it. So if there are overriding legal obligations, say you have to preserve because there's a lawsuit or something like that, that would override a CCPA deletion request for that overlapping data.
Thanks, Jonathan.
Yep.
So the last little item I kind of wanted to touch on before we go to official Q&A and closing was knowing what's in your contracts. So companies need to have an understanding of what's in their contracts so that they can be aware of company obligations and what obligations lie with their vendors or their suppliers. So a different CCPA project that we recently worked with was actually helping in-house counsel kind of get their hands around what was in their contracts, take a look at what a good privacy amendment would be to make sure they were being compliant with the CCPA requirements, and also that they were protecting their company as well. And so we kind of worked with them to go through an exercise of looking at what they'd like to have in their amendment. Actually did a couple of interviews with suppliers and vendors to see how they would respond, and then kind of locked in place our preferred kind of playbook step by step, and then worked on negotiating contracts kind of via a tiered solution. At the same time, we kind of tracked that with the example of the dashboard earlier, where we were able to monitor what our attorneys were doing real time, what questions had been kicked out to different business departments, privacy questions, or whether or not the contract negotiation process was getting hung up with the supplier or the vendor. And that allowed us to report weekly to our client and kind of have a real-time discussion about which contracts were hung up, what we needed to do to move the process along so that we could meet deadlines within the CCPA requirements. So that's kind of a really small snapshot of one way we can assist with the contracting process, but I did want to touch on that before we closed up today. And Sarah, do we have any more questions today, or? Are we ready to close? Does anyone else have anything to add, or have any additional questions come in, Sarah?
Nope, no more questions.
Okay.
Answered everything.
Thank you. All right, well, thank you for joining us today. It has been our pleasure to have this conversation with you. I hope you gained some knowledge and some insight to some of the items that have been on our to-do list of over the past few months with the CCPA coming into play. But if you have any questions, please don't hesitate to reach out to us.
Thanks, everyone. And just as a reminder, the recording will be sent out automatically to anyone if you had to step away from your desk, or if you missed any portion, or if you'd like to share this information with colleagues.
Thank you.